Hi, I'm Marc Winerman, and I've got the pleasure of interviewing Bill Kovacic today. And I had the pleasure previously of working with Bill for a decade. Um, Bill, you wrote sometime before you became a commissioner a piece on the quality of appointments to the FTC, and I'd like to turn the tables on you a bit today and ask you a bit about the quality of your preparation for becoming an FTC commissioner. So I was wondering if we could start by going back to your days in college at Princeton.
Now, the time in Princeton had an important formative event, and I should mention I'm delighted to have the chance to discuss the past with Marc, my dear colleague from my time at the Commission. Two things were very important from my college experience. One is that the focus of concentration in my last 2 years was a public affairs program whose home was the Woodrow Wilson School for Public and International Affairs. The Wilson School program for undergraduates had a major institutional focus. A critical concern was the way in which institutional design shapes substantive outcomes in policymaking. 1971, my first year of courses in the Wilson School, focused on a recently published text by Graham Allison called The Essence of Decision, which quickly became a fixture in political science and public administration programs. And the thesis of Allison's book was that a key reason for disappointing policy results is that academics and policymakers spent so much time thinking about grand substantive concepts that they ignored the basic engineering of how institutions are organized and function. He said the big challenge for policymaking was to cover that last space between the substantive idea and the effective application. Allison's views worked their way through many courses in the school, and a recurring question was not simply what in principle is the best concept, but how to do it. And if you didn't have good answers to how to do it, or explain why past unsuccessful efforts to do it would not be repeated, you were sent back to the drawing board. And that interest in institutional arrangements really took hold during my time as an undergraduate, and I'm extremely fortunate to have been in a program that made that front and center a key element of the educational program. The other influence took place, in a sense, outside the classroom. I worked as a stringer for several newspapers during my 4 years in school, and for 2 years I was the campus stringer for the New York Times. Princeton was located between Philadelphia and New York, a big enough source of news that they wanted some coverage of regular campus activities and sports, too far away, too small to justify a permanent reporter presence, so they hired undergraduates. I did that for 2 years. Not only did it give me a chance, an excuse, an opportunity to write stories that focused on the work of many of Princeton's leading academics and administrators, and the Institute for Advanced Studies, which was also in Princeton. Carl Kazin was the director at the time. But also to see how the university worked. And this was my initial first-hand introduction to what becomes known in economics as public choice economics, looking at how institutions behave as the function of personal preferences, incentives for individual advancement. And I got to see a university close at hand, the rivalry between different departments, the contest for resources, the difficulty that the president of the university had in trying to develop a coherent program to take the archipelago of departments and to try to coax from them a single unified commitment to a vision of what the school would do. I saw this most vividly at the time, and this is 1973. Princeton was receiving, as it still does, a great deal of resources from the predecessor of the Department of Energy to do work in plasma physics, to demonstrate the basic feasibility of fusion as a civilian energy source. The head of the plasma physics laboratory gave me an interview, Melvin Gottlieb, and spoke about how by the end of the century, and that was the 20th century, that well before that, Princeton would probably demonstrate the feasibility of the concept, and that by the year 2000, we would see fully functioning civilian power plants based on the fusion design. I then went from the plasma physics laboratory, which was its own self-contained unit, to speak with the head of the engineering department, Robert John, expecting that he would give a tribute to the plasma physics program and tout its benefits and how this was great that Princeton was one of 4 major research centers in North America getting these resources. Robert John trashed the plasma physics program. He said that Gottlieb's predictions were hopelessly optimistic, that in many ways it was diverting effort away from other useful projects. It took me a while to absorb this, but I realized that A, John was jealous of what was happening at the plasma physics laboratory. He begrudged the significant funding which the program was getting. He couldn't stand the additional attention it was getting at the expense of engineering. And in substance, he also thought that it was undersold. It was my early recognition that institutions and organizations are complex, individual motivations and preferences shape the way they behave, and that you simply can't assume that large organizations of this kind are big, happy families. Oh. These are lessons that have been useful throughout my time since leaving the undergraduate life.
Right. Then you went to Columbia, and you took more time than the norm for somewhat unusual reasons to graduate from Columbia. You want to talk about your time at Columbia, including your time away from Columbia?
I went to Columbia with no real sense of what field of law I would ultimately pursue. My mother's father and her brother, my grandfather and my uncle, in Texas were lawyers. I used to spend parts of the summers working with them, or I should say getting in their way. They humored me while I was a kid. In Canadian Texas, they allowed me to work with them, but I didn't know what field I would likely pursue. And I still had the thought that as hiring possibilities became more robust at a place like the New York Times, I might try to be a journalist. The Times was going through the throes of a difficult downsizing, reconfiguring because of pressure from new dailies like Newsday and from other suburban dailies. They weren't hiring at the time, but I thought maybe that was a path I'd still take. It changed in the spring of 1975. Columbia allowed first years to take a single elective in the second semester. One of the electives offered was trade regulation, the Antitrust course. Harlan Blake was the instructor, Blake of the famous Jones-Blake Bork-Bowman debates over the goals of antitrust law, appearing in Fortune magazine, later represented as a dialogue in the Columbia Law Review. Blake's course was a basic tour through competition law. He used the then first edition, newly published, of the Bob Potofsky case book that is quite famous and popular throughout legal education today. But Blake occasionally would bring a speaker in to speak to his advanced seminar. He would invite the first years to sit in on the presentation. And one evening in the spring of 1975, Blake brought in a specialist in the computer sector. He was a representative of a trade association whose members largely were jousting with IBM, the great monopolist of the time. IBM was then embroiled in a major lawsuit with the Department of Justice for monopolization in many private cases. The speaker represented IBM's antagonists. He spoke about the case, but also talked about legislation that was making its way through the committee process in the Senate, involving a change to the investigative powers of the government agencies, the development of a mandatory notification mechanism for mergers, and a class action recovery mechanism that states would be able to apply on behalf of consumers in their states. After the class, he was the speaker, took some questions, and then Blake and the speaker stood in the front of the room. It was getting late in the afternoon. I was ready to take the subway back to the home in which I lived to have dinner, wondering whether to ask Blake a question that had been posed. And I decided I can wait a bit longer, waited for 5 minutes, and I asked Blake about the legislation. And as I was ready to say thank you and leave, he said, you know, if you're interested in this, I know the staff director of the Senate Antitrust Subcommittee of the Senate Judiciary Committee, and they might be able to take you on for a summer to work as a research assistant. He said, I'll read your exam, I'll see how it goes, and I'll write a letter for you if that goes well. Well, I bet all of my chips on antitrust, prepared as heroically as I could. Did a little bit less well in some of the other classes, but the antitrust grade was enormously successful. Blake wrote a delightful letter for me, and I went to interview in the late spring of 1975 with Howard O'Leary and Chuck Bangert, who respectively were the staff director and principal deputy for Philip Hart's Antitrust and Monopoly Subcommittee in the Senate Judiciary Committee. During the interview, they knew Blake very well. I spoke to them about my interests, and they said, we'd love to have you on, but in the course of a summer, you'll be in a position by the time you have to go back to school of really being able to help us. And we need help for the longer term. That's just not going to do the trick. At that point, I was really ready to say thank you for giving me the time, about to leave, but then Chuck Bangert said, but if you're interested in doing this for a year, you're on. We'll pay you a barely post-13th Amendment wage to do this. You'll work as a research assistant for us, and then you can go back to school. I asked the university for a leave of absence. They gave me one, and come June of 1975, I was employed by the Senate Judiciary Subcommittee on Antitrust and Monopoly. One thing that stuck out in my mind about that is that it did, for purposes of teaching later, tell me a lot about what it meant to be a good teacher. Harlan Blake didn't have to do that for me. If he'd simply answered my question and let me go, I wouldn't have known any differently. He went well out of his way. For a first-year student he barely knew, the course was relatively young. I didn't have a whole lot to say in the classroom. Something he didn't have to do at all, went way out of his way to do that. And in many respects, I owe him everything for what happened since. And from 75 to 76, I was a staff assistant for the majority staff of the Antitrust and Monopoly Subcommittee. I got to work a lot on petroleum matters, but my main pastime was what became ultimately adopted as the Hart-Scott-Rodino Antitrust Improvements Act of 1976. The progression of the statute was fascinating in many ways for me. I got to watch the legislative deliberations inside the committee. I got to see the refinements in the statute over time, and they were significant. There was a basic change that initially the government would have been able to stop almost indefinitely at its own request, the progression of a transaction to make the waiting period as long as they wanted. That was changed around to set limits and then require the government to make a choice to challenge or not challenge. But it was also fascinating to watch the Senate itself at that time. I've kept my Senate telephone directory, and it's quite a stark comparison to see the Senate of '76 to the Senate of today. Many more individuals who I think not only had great intellectual skills, but much more given to a contemplative way of work, thoughtful, far less dogmatic, in a way a sad reflection on, in a sense, how things have changed for us. And to watch Hart in particular, who embodied these values. Hart was a beloved member of the Senate. He'd been in the Senate since the late 1950s. Come 1976, he was afflicted with cancer, and it became apparent from all of his doctor's accounts that he was dying. He would go to the committee meetings and the markup meetings on what was then called S-1284. That was the Senate title for the bill. He would carry with him an airline sickness bag to the committee meetings so he could sit in the room, desperately ill that he was and nauseous from the chemotherapy treatments he was taking, so he could sit and stay at the meetings. And it was really, in many ways, I think, his unique role in the Senate and his unique personality that made it possible for the law to be passed. Parts of the law were enormously contentious. The fluid class recovery mechanism, the parens patriae feature being the most contentious, the civil investigative demand authority for the Department of Justice being the least sensitive, and the pre-merger notification measure in between.
Right.
Hart's own position almost certainly gained the acquiescence of skeptics in the Senate to allow the bill to go to the floor, to allow the cloture motions on the filibusters, there were two of them, to be passed, and ultimately to gain the approval of the White House. Gerald Ford was the president. Ford was being urged by many advisors and the National Association of Manufacturers and the Business Roundtable to veto the measure, mainly because of the parens patriae provision. But this is a point at which the personal relationship between Ford and Hart meant a great deal. They had bonds that tied them together in a way, again, that I don't think we see in our Congress. Different parties went into the legislature at about the same time, both World War II veterans, and an interesting bond built from that. Hart was one of those young kids in the Higgins boats, landing in Normandy on D-Day. He was wounded at Utah Beach, recovered. Ford was a naval officer in the Pacific. There's a famous photograph on an aircraft carrier of a bunch of sailors, enlisted people playing basketball, and the basketball court is one of the elevators used to bring aircraft from the operations and preparation deck up to the flight deck. It's down in the well, and you can see a tall guy with a shock of blonde hair reaching up for the ball, and that's Jerry Ford. Ford saw combat in the Pacific. To a large extent, that created a bond of respect, despite policy differences. No one who'd gone through that shared experience was going to call a colleague a coward or unpatriotic. And Ford respected Hart enormously. And in the late stages of the deliberations, Bernie Nash, the principal staff person on Hart's committee responsible for the preparation and pursuit of this, got a phone call from the White House and said the president's going to sign the bill, and he's going to do it for Phil Hart. You can't model that in advance, but by the most remarkable of individual circumstances, the bill becomes law in 1976.
And I've also heard you talk about what expectations you had for second request when you were helping to draft that bill.
I was assigned the role of writing some of the paragraphs that become that well-known legislative history.
Yep.
In the spontaneous, well-rehearsed dialogues that take place. I didn't conceive the arguments, but I did write them, and part of the dialogue involved the magnitude of the likely second request. The question raised by opponents or skeptics was, this is going to simply sweep in huge stacks of information. It'll be enormously burdensome, costly to assemble and review. And the proponents wanted to give assurances that wasn't true. I can recall writing a paragraph that I believe is in the legislative history that said, at most, the typical second request would elicit a few important documents that would easily fit inside of a filing cabinet. The only way I can reconcile that prediction to actual practice is that the size of the filing cabinet wasn't specified. And if you imagine an immense filing cabinet, it would be satisfactory. I think another thing I had my fingerprints on was writing a few passages that talked about the likely number of notifiable transactions. How many people would have to respond to this by notifying? And I believe that the legislative history said this is designed to pick up the 100 largest transactions, maybe 100. I think the number of filings in the first year of operations exceeded 1,000, just off by a factor of 10.
Yep. Well, after that, you started on a trend demonstrated by a number of subsequent commissioners who I call occasionally the repeat offenders, who keep coming here, coming to the FTC, leaving and coming back, and you're one of our 3-time repeaters. And so could you tell us about your first period at the commission?
I spent 1 year after Columbia working as a law clerk for a federal judge in Baltimore, Judge Rosal Thompson. And toward the end of the Baltimore year, I wanted to go either to the Department of Justice or the FTC. The other option was to go to Squire Sanders and Dempsey, which had absorbed a wonderful little antitrust and trade regulation boutique that I'd worked for in the summer of 1977 called Nicholson and Carter. Jim Nicholson was a Federal Trade Commission commissioner in the late 1960s. They were absorbed by Squire Sanders. It seemed at the time they had really gotten rolling, that the small boutique firm doing lots of work on FTC rulemaking and major litigation, industry-wide matters would be the wave of the future, and that would be supportable. That possibility collapses. They were quite fortunate they merged when they did. Those were the 3 options for me. I can recall having an interview in Philadelphia with a young guy named Don Clowder, who interviewed me for the honors program at the Department of Justice. I ultimately went to the FTC because I'd done some work for them in the summer of 1978 as a result of a consulting arrangement that Harvey Goldschmidt, who was one of my instructors at Columbia, had arranged. Harvey, again, was extraordinarily generous and helpful, above and beyond the call of duty to me in shaping a career path. He introduced me to the FTC. He introduced me to a guy he was doing some work with named Jack Kirkwood, who was in the Bureau of Competition, who headed the planning office of the Bureau of Competition at the time. And having had a chance to work with Jack and his colleagues a bit before the clerkship, that convinced me that I wanted to go back to the FTC and worked with them. And I began at the commission in the fall of 1979.
And what did you find during your first experience here? What did you see that influenced you later as a commissioner?
Things that are happy memories and that were helpful mainly came about from working inside of Jack Kirkwood's office. Jack was a prototype of the academic, quasi-academic scholar who was also a skillful practitioner and policy analyst. Jack conceived of the planning office as having 3 key functions. It was going to write detailed research papers that would be of use to the entire staff, would be published in some form, but it would obviate the need to write the same memo analyzing a recurring problem again and again. The second was to act as an advisor, a consultant, the equivalent of an in-house consulting shop, as well as think tank, that would work on individual cases. And the third was to manage a just developing program in the Bureau of Competition to do evaluations of completed matters. I got to do all 3 of these for Jack. I got to work on long research papers that became published articles. I got to work on a number of high-profile commission matters. I got to work, some of them were very unhappy, like In Re Exxon, which was a bit of a chain gang for people assigned to it. Junior attorneys knowing about how badly the case was going. Recruits, I would seek to specify as a term of employment that they would not have to work on the Exxon case. Worked on Borden Real Lemon, also successful in form, but resulted in a true fizzle of a settlement, given the likelihood that the Department of Justice was going to come in against us before the Supreme Court on the case. And got to work on evaluations too. I got to supervise a project being run by a then very junior assistant professor on the Stanford economics faculty, a guy named Tim Bresnahan, who goes on to other things. Tim did an evaluation of the effects of the Xerox monopolization settlement that the FTC achieved in 1975. And in this group, I had the opportunity to work with a wonderful collection of analysts, Jim Hurwitz, Bob Land, Ken Davidson, Neil Averett, Ross Petty, David Frankel, Don Clark, as well as Jack himself. That model of policymaking that emphasized a research function, the emphasis on evaluation, Jack believed deeply that you had to look back and see how things turned out as a way of deciding what you were going to do next. One of the key research projects was an examination of past vertical restraints decisions, and I vividly remember how it started a rethink on my part about the appropriate boundaries of vertical restraints doctrine. One of the conclusions of the report that Jack and Bob Land and Ron Lafferty wrote was that the case for the per se ban on resale price maintenance is not supportable from what we see in the studies that we've just done. But also the notion that these kinds of research would inform a litigation program. Those ideas stuck through me throughout my career, and you'll see things, aspects of what I was interested in doing when I was at the FTC and outside that have their links back to those. The less happy part of it was that the roof was falling in on the FTC in these years. 79, 80, 81, contentious, difficult years. Many of the matters I worked on were ghastly litigation failures. Others that I watched at close hand were also grisly defeats. The Congress had been galvanized by complaints from a variety of industry groups offended by the Commission's programs on the competition and consumer protection side alike. And they coalesced in a powerful movement to restrict the FTC's authority. And the opprobrium visited upon the agency was so strong that on the day before the presidential elections in November 1980, Walter Mondale went to Battle Creek, Michigan, the headquarters of Kellogg. Kellogg was one of the FTC's respondents in the shared monopoly cereal case. And Mondale released a statement and a report that said the administration would not support the breakup of Kellogg, would support legislation to prevent the FTC from achieving divestiture or other structural remedies in the case. And by my quick count, I can't recall another time when the head of state or the vice president of the United States seeking votes in an election has offered to throw the weight of the administration behind an effort to disable a case if re-election took place. All of this happened before Ronald Reagan set a foot in Washington as president of the United States. This was a president who was a Democrat, substantial majorities in both the House and the Senate, turning upon the agency. This left a lasting impression, both an awareness of the political dimension of what the agency does and how, though it is called independent, that autonomy is not guaranteed, and that it always has to be attuned to how its behavior affects powerful political constituencies. The other lasting image for me is that there has to be a good match between capabilities and commitments. The FTC had a near-death experience a decade before, 1969, 1970. The Kirkpatrick Commission and the Ralph Nader study rubbished the FTC as being inadequate, weak, timid. The FTC, in response to these admonitions, develops a very bold program in the 70s. But throughout the development of the bold program, no one was asking, do we have the capabilities to deliver on these commitments? And another lesson I took away from that early experience was the importance of making sure that as you add additional commitments, litigation, rulemaking, and others, there has to be the capacity to deliver. And that, again, was a further awareness of how institutional capability determines substantive policy results.
And after that, now you went to Brian Cave.
In the last couple of years at the FTC during Jim Miller's chairmanship, I got to write some speeches for Jim Miller. I got to watch the efforts to redirect the agency. I was hugely skeptical of this. My offer letter from Mike Perchuk, who was the chairman, said, "Welcome to the world's greatest public interest law firm." And it was a redirection of my own thinking that took place, partly by watching things fall out of the sky, watching the opprobrium that had been visited on the agency. And by the time Jim Miller came to the agency, it was an ailing firm. He did not inherit a great firm. I would have been smoother in the transition. I would have been somewhat more discriminating in deciding what had gone well and what had not. Many things had been done well. Many things had not been done well. But to make good choices between them. But I also was acquainted in these last couple of years at the FTC to a young guy named Tim Muris, who had been the head of the Bureau of Consumer Protection and then the head of the Bureau of Competition, and got to know him, at least on a limited scale. Then left to go to private practice for 3 years to the Bryan Cave Law Firm in its Washington office, but spent lots of time in St. Louis. Two things there stand out for me. I got to spend a lot of time with working on matters involving what was then known as McDonnell Douglas, to learn a lot about the process of high-tech product development and contracting, and to work a lot for the Brown Shoe Company. And to see the aftermath of its very unsuccessful jousts with the antitrust system in the 1960s regarding mergers and exclusive dealing. And then in 1986, through a classmate from college, I was told of an opening at George Mason University, just on the cusp of getting ABA accreditation, the opportunity to join the faculty and teach. And in June of 1986, I became an academic.
And along the way, you developed an interest, or expanded your interest in international antitrust. Could you talk about that a bit?
Yeah, when I was in law school, this was a very limited part of the antitrust universe. I had a conversation with one advisor at the end of 1978. I said, he asked, "What would you like to do with your degree now that you're finishing the program?" I said, "I'd like to have a career in international antitrust law." And he shook his head with great sadness and said, "I can't advise you to go into a field that will never be important." In 1978, that was not a foolish recommendation. By 1986 to 1982, 1996, 96, 97, 98, when I met George Mason, it changes completely. And the big change for me came in 1992. I got a phone call from a group that did work for the Agency for International Development who said, "One of your former students is a next-door neighbor. I asked your former student if she knew anyone, an academic who does antitrust, who might be willing to spend a month in Zimbabwe working on a new competition law. And she said, call you. Are you interested?" I said, I am. I've never done something like this, and almost exactly 20 years ago this month, I went to Harare for a month to work on development of Zimbabwe's competition law. That was the start of an extensive interaction over time with foreign governments in the process of making the transition from central planning to a market economy. I've gotten to work with, on a close, extended basis with more than 15, 16 of them. Zimbabwe was the first. But for me, the other key part of learning in that process was being asked by the Zimbabweans, what's the best arrangement? What's the best system? Mm-hmm. What's the best framework for the law and its implementation? Right. You can't answer that by beginning to ask questions that lead you to re-examine what your own system does. Mm-hmm. And that was a further turn in thinking more and more about how systems are organized, how they operate, how they perform, how we know whether they're doing a good job.
Would you like to talk any more additionally about your years in academia?
One of the most important things was the chance to teach contract law and antitrust, which have some very close relationships. to teach international courses involving development, to teach public procurement, but one of the most important parts of this experience was that down the hallway was this young guy, Tim Muris, who had been at the Federal Trade Commission, worked in the Office of Management and Budget, but then in 1987 decided to join the George Mason faculty. I knew Tim a little bit from my previous time at the FTC, but got to know him a lot better while I was at George Mason, and for 10 years was his colleague there before I went to visit at George Washington and then became a permanent member of the faculty. It was through that relationship, talking about the FTC, talking about regulation, that in December of 2000, I got a phone call from Tim, who said, I'm over at the Office of Executive Personnel near the White House. I've just learned that the President-elect, George W. Bush, is going to nominate me to succeed Bob Potofsky as the chairman of the Federal Trade Commission. Would you like to be the general counsel of the Federal Trade Commission? I said, it's a great idea, but I have to caution you that the only person I've ever managed in my life is myself, and not always particularly well. And I have never stood up in a courtroom as an advocate in the case. So I know something about the theory of litigation. I don't know much about the practice of it. And he said, that's fine. I have other roles carved out for you, and they've got great people there who can handle the things that aren't first nature to you. You can work extensively on international matters. You can work on policy planning and development. You can assist in conveying the message that we want to with the program, and oh yes, you'll be able to work with first-rate people to pick you up on things you don't do. On that, he was exactly right. The ensemble of people in the General Counsel's office, the best law office I've ever worked in, both from top management all the way through the career staff, carried me along quite handsomely in this process. Let me get to know, see something about the new FTC, the FTC that I had left before, that it was a far more capable place. Many senior people, like Marc Winerman, had come early to begin their careers there and had stayed. This was a problem when I was a kid there the first time. You had an uneven distribution of political appointees who were very good at the top end, young hotshots being brought in and recruited, but a very uneven mix of the staff in between. By no means a wasteland, but a real gap in the ranks of the middle senior manager with lots of experience and a great deal of capability. That had changed. So that by the time going back, and I could see this in the General Counsel's office, an extraordinary upgrade in the human capital across the agency. And in June 2001, I came back to the commission to be the general counsel.
What did you find during the general counsel, turning this into your qualifications and your preparation for being a commissioner and later chairman of the FTC?
I was delighted to see how much of what I'd learned before was, in a sense, portable and applicable to the experience at the Commission. The opportunity to study the institution for years and years put me in a position to understand what it was doing now and what it might do in the future. I knew over a third of the people in the phone book, which meant that I didn't come in as a stranger, and I could learn quickly from people I'd known for a lifetime, professional lifetime, to work on projects. I also, by reason of having worked on international projects and spent basically the previous 10 years on international relations matters, seeing new institutions from the ground up, seeing the international network of bodies such as the OECD and UNCTAD that knit them together, seeing where there were gaps in the system that could be fixed, a reason I was an enthusiastic early supporter of the idea that became the International Competition Network, and having a sense of what an agency had to do to shape a program, the importance of having a good match between commitments and capabilities. And I got to work for a chairman who understood all of these things quite well, much in a way that a good coach puts an athlete in a position where you're likely to, where your skills are well suited to what you're going to do. I was in effect, a good third baseman. He didn't tell me to play center field or to pitch. He said, "You'll be a good third baseman." That was a good choice. It was a good fit, so that my background and experience was a good complement to the career civil servants who were there. I had just tremendous deputies. John Grobert, who was the principal deputy who carried me along, Chris White, folks like David Shanka, Susan DeSanti, who brought in the policy planning group to be part of the general counsel's office. Up and down the ranks of the agency and the office, an extraordinary group that I could work with, and I found that what I had learned fit well with what I had to do with the commission.
And your preparation set you up not only to be the commissioner and the chairman of the FTC, but also, I believe it's vice chairman for outreach at
for the International Competition Network, to see this new institution form and develop, to see with great pleasure how much effort and commitment the Federal Trade Commission and Department of Justice committed to this, to have the full support of my chairman, but also to move into these other positions, first as a commissioner, as chairman for a year with a very good idea of how to do the job well. I had very good role models to work with. I had, most of all, I got to work a lot for Tim and to watch him firsthand and to learn a lot about leadership, to see how lavishly and extensively he praised the work of his predecessor, Bob Potofsky. Tim had come by that point to see the Commission's growth and development as being a relay race, not an individual event, and the extent to which he built extensively on that link. He told, I remember a senior staff meeting early on, he said, "If I ever hear you criticize the Clinton administration's program here, if I ever hear you criticize Bob, I'll dismiss you. You'll be fired." Got that? Everyone nodded. Pretty clear. But that was a theme that he developed for the longer term, to get to watch Tim as a leader. And you see a leader do well when times are worse, not best. The do not call mechanism was one of the flagship parts of his chairmanship, enormously successful, but bitterly contested in litigation when the rule was proposed. Within a week, 2 district courts enjoined the implementation of the rule. And as we were seeking a stay, the question was, were we going to be in the courts for another 5 years plus, right, or were we going to succeed in rolling this out? Once the injunctions were handed out against us, I was despondent. I thought this shows that you don't bring an academic without courtroom experience in to be the general counsel. I didn't argue the cases. Our chief litigator, Larry Wagman, was also argue the case, was also discouraged. At the meeting after these results with the senior staff, Mira said, "You guys are doing exactly what you're supposed to be doing. This program is unfolding precisely the way, according to the substantive elements and strategy that I chose. You are faithfully carrying out what I asked you to do. You're doing a good job. We're going to prevail." Several of us mentioned to him, if you want someone else, if you think there's a better choice to come in and handle these responsibilities, you can do it. That's an oblique way of saying if you want to plug someone else into this, you can. And he said, "Absolutely not. You guys are doing a great job. We're going to prevail. We're going to try A, B, C, and D to make this work." At that moment, when things were at their worst, that's really my favorite day at the FTC. Wow. The worst day became the best day because it showed the kind of leadership that you needed to progress. It lifted everybody's spirits, and God bless Larry Wagman and the 10th Circuit. We were able to get a favorable result. We got a stay. We got a good decision on the merits. But coming into being a member of the commission and the chair, I got to watch directly great role models like Tim Muris, derivatively at a distance to watch folks like Bob Potofsky, to have seen Jim Miller do a lot of things that shored the agency up. I was very well prepared at the moment I got to be in the front offices of the commission.
And we've spoken about many of your influences through various positions you held in various schools you attended. Are there any other influences that you'd like to mention? I'd
say one of the one of the most important over time has been the chance to work side by side with so many superb professionals, members of the agency, inside the commission, and absolutely superb leaders outside the agency. I mentioned many of I got to know inside the commission, but it's been the chance to see the extraordinary pool of talent outside of North America, outside the United States. The great leadership that's driven the development of policy in Canada and Mexico. To work with people like John Fingleton, now the soon-to-be departing chair of the Office of Fair Trading, and the head of the steering group of the International Competition Network, to see superb leaders in other countries doing this work, as well as to have worked with the extraordinary team that the FTC developed. When I was at the FTC the first time, I couldn't have made that claim. But to be asked where the FTC stands today, under John's chairmanship, throughout the decades that have unfolded, I think of an interview that I read of a journalist who interviewed the head of the art collection of the Hermitage in St. Petersburg. He was at the Hermitage. Art director was asked, "Do you have the best collection of art in the world here?" He said, "Oh, I don't know. That's a hard question. There are many good ones. Great museums all over the world." And he paused, and they said, "Well, I can assure you of one thing. We are not the second." So when I ask, where does the FTC stand in the ranks of competition and consumer protection agencies and of public institutions around the world, it is not the second.
Well, thank you so much for the time. And after a decade of working with you, I learned a lot of new stuff today, Bill.
Well, Mark, thank you. And I would say no element of my experience at the FTC was more satisfying than to get to work with you day in and day out.
Oh,
and
thank you.
I look forward to the great days as a co-author to come.
Thank you.
Thank you.
Great.